Hello, and welcome to my talk, Turning the Tides on Adverse Impact, Adrift in My Personal Raft. My name is Dennis Doverspike. I have about 40 years of experience in consulting and teaching in various testing and personnel selection issues. As the name suggests, this talks about adverse impact. And also, as the title suggests, it's about what I see as the rapid changes or the sort of source of my discontent when it comes to adverse impact. The way we define and test for adverse impact is continually changing. It's changing not just because of the science or the statistics, but also because of the law and legal rulings. In a lot of ways, adverse impact is about as much about the law and court cases and legal rulings as it is about science. It's really a technology that is consistently informed by court cases, legal rulings, the law, and certainly if there was to be any new legislation that would get through Congress. So adverse impact is more of a technology than a science. It's certainly a technology informed by science or statistics, but it's also a technology informed by the law. And of course, I am not a lawyer and I do not give legal advice. There are a lot of probably topics related to adverse impact. We won't be dealing with them here, but that would include various measures of differences by race, ethnicity, or protected class that use the mean differences or D, various attempts to measure internal bias in tests such as differential item functioning and differential test functioning, attempts to measure external bias in tests, including differential validity, and then measures of fairness, including those based on the Clery definition, equal outcomes definitions, content definitions, and others. We're not going to be dealing with those topics, but those are all topics related to adverse impact. Okay, this is just a general speaker conflict of interest statement. Learning objectives, our main learning objectives are from a knowledge perspective to develop knowledge of the conceptual history of adverse impact. From a skill perspective, skill in understanding how adverse impact analysis is applied in legal related proceedings. And in terms of understanding interaction, how adverse impact and the analysis of adverse impact interacts with recruitment and the changing nature of adverse impact literature and the adverse impact recruitment relationship. Our agenda overview, we're going to talk about adverse impact, fairness, and merit. Should I really worry about adverse impact? And the buts, definitions of adverse impact, race norming, recruitment, and then wrap up. Okay, adverse impact, how can we define it? Well, we'll define here adverse impact as a judgment that there is a difference in the probability of obtaining a desired personnel selection outcome for a member of a protected group as compared to a member of the majority group. And it's a judgment that's informed by the legal and statistical literatures. So it's really a judgment based on technology. Now, there's also fairness. Fairness is also informed by the legal and statistical literatures, but fairness is the idea that after controlling for merit, we can make a judgment that there is a difference in the probability of obtaining a desired personnel selection outcome for a member of a protected group as compared to a member of the majority group. Okay, so a very common question that I get a lot is, do I really have to worry about adverse impact? And the answer there is a little bit complex, but there's a number of factors that probably go into it. But first, I'd probably ask you, do you worry right now? And if you do worry, why do you worry? Have you ever had an adverse impact claim? And what are the frequent types of legal related claims you do receive? It's probably somewhat surprising, but a lot of employers never really have adverse impact claims. They do have a lot of other probably claims or common claims. Some of them other common claims that are related to selection are negligent hiring, invasion of privacy, disparate treatment, and grievances from unions. So these four types of claims may be much more common than an adverse impact claim, and employers may worry then about these claims more than they worry about an adverse impact claim. In terms of analyzing our risk of adverse impact, I think there's a number of factors that go into that. You could probably create sort of a decision tree, but one would be how many applicants I have. The fewer applicants you have, the less you have to worry about adverse impact. The more applicants you have, the more you have to worry. The diversity of my applicants. The more diverse my applicants, the more I have different representation from different protected classes, the more I have to worry about adverse impact. The number of hires. The fewer people I'm hiring, the less I have to worry about adverse impact. The more people I'm hiring, the more I have to worry about adverse impact. And then diversity of hires. If I'm already hiring a very diverse sample of individuals, then I may or may not have to worry more about adverse impact. And it sort of all depends upon the numbers and my mix of numbers. Buts. This is a list of common buts you hear from companies. But one of the most common is, but I am a good company. You know, people often argue I'm a good company, my employees love me, I'm a diverse employer. It really doesn't matter. All those things could be true and you can still get an adverse impact claim. As a matter of fact, many companies that think they're good employers and think they don't have to worry, that's when you know there's going to be a problem. I have a minority chief human resource officer. Again, you'll sometimes hear people think, well, how can I get an adverse impact claim? After all, the person in charge of all my hiring is a minority. Again, that does not matter. Companies that have minority CHROs can certainly have adverse impact claims and can certainly lose adverse impact litigation. But I'm way overrepresented. I have significant diversity in my company. Again, this used to be a better argument, but the relevant court case is Connecticut v. Teal, which is a bottom line case. In Connecticut v. Teal, the Supreme Court held that petitioner's non-discriminatory bottom line does not preclude respondents from establishing a prima facie case, nor does it provide petitioners with a defense to such a case. So just because you have a good bottom line doesn't mean you can't be using a test that still discriminates based on an adverse impact theory. So again, in Connecticut v. Teal, the petitioners urged that this bottom line result that was more favorable in fact to blacks than to whites was a complete defense to a suit from African Americans that there was adverse impact on a test. And of course, they lost. But I over-recruit. Now, actually, the Uniform Guidelines in 4D says that greater differences in selection rate may not constitute adverse impact where the differences are based on small numbers and are not statistically significant, or where special recruiting or other programs cause the pool of minority or female candidates to be atypical of the normal pool of applicants from that group. So the significant thing here is the second part, or where special recruiting or other programs cause the pool of minority or female candidates to be atypical of the normal pool of applicants from that group. It appears that very few people actually care about this provision of the Uniform Guidelines, at least when it comes to establishing adverse impact in court. As a matter of fact, over-recruiting may make you more susceptible to an adverse impact claim. Another but I use an interview or a subjective evaluation, not a test. This is the idea that, hey, all I'm using is an interview. I can't be found guilty of adverse impact. I use a subjective evaluation. Of course, the classic cases here are Watson v. Fort Worth Bank and Trust, which established that subjective devices could be held to or could be attacked under an adverse impact theory. Although we will say in Walmart v. Dukes, there is some erosion of that theory, but another case that occurred around the same time, McLean versus Lufkin Industries, went very much the opposite direction of Walmart v. Dukes. So at this point, we would still say, hey, just because you have a subjective device does not mean you're protected from an adverse impact argument. So what can we say here as to risks? Well, in general, objective or professionally developed pre-employment tests will have more adverse impact than subjective decisions, but that's not always true. However, it's probably true that subjective decisions may be harder to attack and litigate, and There we might turn to Walmart v. Dukes. However, professionally developed tests are probably much easier to defend than subjective decisions, although because judges and regulatory agencies may have more problems with subjective decisions. And attorneys on both sides seem to dislike subjective decisions and the inconsistency that subjectivity brings. Two other decisions of note, the recent decisions, Howe v. City of Akron and Reese or Ricky. Howe v. City of Akron was a large jury verdict. It's notable in that a very similar test was used with the fire department in the city of Akron for both lieutenant and captain. Yet the court held that the lieutenant test unlawfully discriminated against African Americans, and a highly similar test at the captain level unlawfully discriminated against whites. And at both levels, there was unlawful discrimination on the basis of age. Of course, Reese or Ricky v. Di Stefano is another critical case from 2009, a Supreme Court case. This was brought by white and Hispanic firefighters after a test was thrown out by the city of New Haven, Connecticut. And in this Supreme Court case, the court ruled that there must be a strong basis and evidence that the test results would violate the disparate impact provisions of Title VII if you want to throw out the test. Some implications of the Reese decision. It may be actually easier to validate tests based on this decision. It may be harder to throw tests out just because of adverse impact. It may be harder to do certain types of post-test adjustments. Okay, now some basic definitions. We've waited pretty long to get to definitions, but some basic definitions of adverse impact. This is, of course, the famous adverse impact ratio. An example, we have two groups. We've labeled one the minority group, the other the majority group. We have 100 minority applicants, 200 majority group applicants, 80 minorities pass, 60 majority group members pass. That gives us a selection ratio. Probably more accurately, it's a hiring rate, but a hiring rate or a selection ratio of 0.118 for minorities and a selection ratio of 0.30 for the majority group. To get our adverse impact ratio, we just take 0.18 divided by 0.30. If that's less than 0.80, we conclude there's adverse impact. In this case, it's 0.60. So what would you conclude? If you said adverse impact is present, you would be correct. The other way of testing for adverse impact is statistically, and this can involve calculating the chi-square, the Fisher exact test, or if we have multiple levels or multiple groups, the Mantel-Hansel statistic. This again is pretty straightforward if you use statistical procedures. Here we're illustrating it using SPSS. If we want to use the chi-square Fisher's exact test, first we set up our data. We of course have to have some sort of protected group variable, and we have to have some result, pass, fail, hired, not hired. We then, if we're doing it in SPSS, we just say analyze descriptive statistics crosstabs. And we set up our analysis. We tell it we want a chi-square. We can ask for additional data. And then we get our results. This is a little hard to see, but in this case, neither the chi-square nor the Fisher exact test is significant. SPSS will give us both the chi-square and the Fisher exact test. In a more complicated situation, I'm going to go through this sort of quickly. We can run through the Mantel-Hansel test. The Mantel-Hansel test would be the same. We define our protected group variable. We define our results variable. But now we're adding another variable, which would be stratification by year, by part of the organization, by whatever it may be. So again, if we're in SPSS, we would say analyze descriptive statistics crosstabs. We select our row, our column, and our stratification or layer variable. We tell it we want a Mantel-Hansel. Again, we can ask for additional data. We run it, and again, this is a little hard to see, but in this case, the Mantel-Hansel is non-significant. Okay, so this brings us to, I think, where adverse impact has really changed recently, or the way we look at adverse impact, and that's in what the introduction of the terms practically versus statistically significant. And what does this distinction between practically and statistically significant mean? And today we would say, if we want to look at practical significance, we're basically talking about the 80% rule, or what we often call the adverse impact ratio. If we want to look at statistical significance, we're looking at the Fisher-Exact test, although it could be some other similar test of statistical significance. So the logical question is, how is this a change? How did our definitions change? Well, that's a good question. It used to mean, I think, that practical really meant practical. So practical meant, is this a practical result? And of course, practical in that context was a judgment. But because of court cases that have occurred in the last 5 to 10 years, practicals come to mean the adverse impact ratio. At one time, practical also sometimes meant what was called the flip-flop rule, or the -1 or 2 rule. But again, I think now it means the adverse impact ratio. A really long time ago, practical was the swinging gate, or adverse impact, or the adverse impact ratio at least was the swinging gate. So this was a concept that you first did your adverse impact ratio, or some other measure of practical adverse impact, and that was a swinging gate to doing a test of statistical significance. So you only did the test of statistical significance if your adverse impact ratio was less than 80%. But that changed, and that changed again about 10 or more years ago to where people started arguing for an equal weighting of practical and statistical significance. And then about, again, 5 to 10 years ago, there was another shift, and that shift was to saying, hey, the heavyweight should be put on statistical significance. And statistical significance should be given primacy or dominance. However, for many of you out there, if you're just doing a simple or straightforward test of adverse impact, you may still be relying upon the adverse impact ratio. I certainly think there's nothing wrong with that. But if we're getting into what's probably necessary or essential for litigation or for legal purposes, the emphasis is now on statistical significance. And really, I mean, if you're getting to that point, you should probably have an expert coming in who has expertise in performing the statistical analysis of adverse impact. Okay, so what were some of these court cases? Well, two of the big court cases really, Isabel versus Memphis, which was actually a 2005 case, almost 15 years ago, and then Jones v. Boston, which where the rulings were in 2014, 2016. Jones versus Boston was a case where there were 8 police officers, a police cadet, and a 911 operator who argued that there was adverse impact in the use of a hair drug test. So sort of a unique case. But what's important here is again, the ruling that and in this case, the court ruled that the EEOC rule of thumb was not controlling. Instead, because the difference in exam results by race was indisputably statistically significant, we concluded that the officers prevailed as a matter of law on the first prong of the 3-pronged disparate impact inquiry. So where it says the EEOC rule of thumb, they're talking about the adverse impact ratio. So they're saying the adverse impact ratio is not controlling. What is controlling is statistical significance. So in summary, we have seen that there's been this shift in thought regarding the relative weight of what we are now labeling practical versus statistically significant adverse impact. As a matter of fact, there's been a change in the very definition of practically significant adverse impact. It's important. We could go back to the Technical Advisory Committee report on best practices in adverse impact that was done by the Center for Corporate Equality. And we can note that they recommended that measures of both statistical and practical significance should be included in determining the existence of adverse impact. However, we would note here too that their definition of practical significance is really not limited to the adverse impact ratio, but is more similar to what we talked about before. The older definition of practical as meaning important or of practical real-world importance. And really, the report is generally negative towards the use of the adverse impact ratio or the 80% rule. So in terms of disparate impact, we mentioned before the three-prong approach, and this here is the three-prong approach. So the three-prong approach is that under a theory of discrimination based on the disparate impact theory of discrimination, the case usually proceeds through these three prongs, where the three prongs are a determination of whether there's adverse impact or not, number one. Number two, is the test valid or not? And three, are there alternative devices that might result in equal validity but have less adverse impact? So that's the three-prong approach. I'm not totally happy with the three-prong approach because I really think there should be a fourth prong. Historically, there probably was a fourth prong, and that fourth prong was for fairness. So I might argue that there should be a four-prong approach to disparate impact, where the four prongs would be determination of adverse impact, is the test valid, are there alternative devices, and then an analysis of fairness in these selection systems. I'd also, in sort of closing this segment, I'd say that I think a very important but often overlooked court case is Guardians v. New York, 1980. Why I think this case is so important is basically this case said, look, we can take the uniform guidelines and reduce them to 5 pretty simple steps. We can distill from the uniform guidelines 5 simple steps that with the content valid approach you should follow to justify the validity of the test. And those 5 steps are having a suitable job analysis, having reasonable competence in the construction of the test, or there being reasonable competence in the construction of the test, that the content of the test must be related to the job, so there must be a linkage between the content of the test and the job, that the content of the test must be representative of the job. So that would mean that the major aspects of the job are covered by the test, or at least by the selection battery, and that the scoring system actually does result in the selection of better performers. So another question that comes up frequently is, why can't I have a quota or race norm? It's probably a legitimate question. It would certainly eliminate adverse impact to have a quota or race norm, at least for certain protected classes. And prior to 1991 or pre-1991, the answer to this question might have been a qualified yes. Perhaps you could have a quota or race norm. And in fact, many tests probably prior to 1991 did have sort of race norming, even if it wasn't publicly disclosed or transparent. But that changed with the Civil Rights Act of 1991, which had a prohibition on that type of race norming. Now, the question is, does this prohibition still apply? Because the critical cases here are probably the FBI cases, Bauer v. Lynch and Bauer v. Holder. These both dealt with physical fitness tests that had gender norms, and the Fourth Circuit ruled that separate norms or cutoffs were not discriminatory when used to account for gender-related physiological differences. So one interesting question we could ask, which really hasn't been asked much in the literature yet, is, well, how far can we extend this logic? Can we extend it to other things like race-related differences or ethnic group-related differences in other types of psychological constructs, such as intelligence or personality or whatever it might be? I don't know, that's just pure speculation, but there is the question of how far we could then take this logic. And of course, related to this, though, is what's become more and more popular, and we might ask how it fits with this prohibition on norming, on race norming, is the use of dashboarding or algorithms to detect adverse impact. So a number of test publishers are offering this in consulting companies. It's become more popular. We might ask the question, is it legal, though? Is it legal to have machine intelligence that detects when adverse impact is occurring and then adjusts the weights or the way the tests are scored to eliminate that adverse impact? Again, it's not a question too many people have looked at, but I think it's an interesting question. Recruitment challenges. There's a lot of recent recruitment challenges related to adverse impact. Now, technically, if you read the uniform guidelines, recruitment is not covered by the uniform guidelines. So it's specifically mentioned that recruitment is not covered. And that's probably because there was a desire to have organizations actually over-recruit minorities or have special stepped up efforts to recruit minorities. So I think there was that intention, and so the uniform guidelines excluded recruitment from being covered by the guidelines. But now we often have this sort of digital type of recruitment where you get into a mixing of selection and recruitment. And there's a lot of different examples of this. Probably one of the most recent ones was one where Verizon placed an ad on Facebook to recruit applicants. The promotion was set to run on the Facebook feeds of users 25 to 36-year-olds for 36-year-olds. Years old. And then so a vast majority of the hundreds of millions of people who check Facebook every day did not even know this exact ad existed because it was targeted to 25 to 36-year-olds. Now you could ask, is that age discrimination? Verizon is among dozens of the nation's leading employers that have placed recruitment ads that are in fact targeted to particular age groups. And it's not just age groups. So there was a recent case involving Canada, but these are just some examples of clearly targeted ads that mention ethnicity or race. So the first one is just for Santa Claus, seeking Caucasian men to play Santa Claus. It comes from Australia in 2018. Now, it's a whole separate topic as to whether this might be a BFOQ, but it's an interesting question. Does this kind of recruitment that targets or mentions particular ethnicity, is it in itself then discriminatory? And what about if we target then minority groups? So in Canada in 2013, there was a situation where the CBC actually asked for any race except Caucasian. So they asked for people to submit audition tapes only if they were any race except Caucasian. And then another recent example was Cite. They had a job description or an ad that said they wanted a preferably Caucasian candidate with technical background knowledge, etc. And the reason probably was that they were an Indian American firm. And it's possible, of course, that whites might have been a minority. And if whites were a minority or Caucasians were a minority, then you could argue that perhaps targeting recruitment at Caucasians or whites would actually not be illegal. Now, I'm not saying I agree with that. I'm saying that's the argument could be made. I mean, this is, of course, an extreme example. One ad from Canada saying anyone except Caucasians, an ad from Australia looking for Caucasians, and then another ad that specifically was looking for Caucasians with good technical background. Now, again, it may have been because that company actually was underrepresented in terms of whites. Okay, so that brings us to the end. If you have any questions, please email them to Dennis Doverspike at doverspikeconsulting.com. If you're in search of books, I have a number of books: Essentials of Personnel Assessment and Selection and Becoming an Industrial Organizational Psychologist. If you're interested in references, Here's some major adverse impact references I think you can turn to, both books and the uniform guideline references. And that brings us to the end. Thank you very much, and I hope you enjoyed this short talk on adverse impact.